A new law just went into effect that could turn your bedroom into a crime scene. And if you live in California or Illinois, the gun you keep for home defense could cost you $10,000 in fines and possibly your freedom. Even if you've never fired it, even if you don't have kids, even if you've done everything right your entire life. Because starting January 1st, 2026, the box under your bed, the drawer in your nightstand, the gun safe you thought was good enough, all of that might now be illegal. And here's the scariest part. You could be charged with a crime even if nothing bad happens. Even if nobody gets hurt, just for how you store your legally owned firearm in your own home. Quick question before we dive in. Are you subscribed yet? Because what I'm about to reveal affects millions of gun owners in 2 of the largest states in America. And 90% of them have no idea their storage setup just became a felony. Hit that subscribe button right now so you don't become a statistic. Here's what just happened. California passed Senate Bill 53, and Illinois passed what they're calling the Safe Gun Storage Act. Both laws went into effect in January 2026, and both laws completely changed the rules for how you must store firearms in your home. But here's what nobody's talking about. These aren't just laws that say you should lock up your guns. These are laws that say if you don't lock them up the right way, in the right container, under the right circumstances, you are committing a crime. And the penalties are severe. We're talking about fines that start at $1,000 and can go as high as $10,000. We're talking about misdemeanor charges that can turn into felonies if someone gets injured. We're talking about losing your gun rights permanently if you're convicted. And we're talking about criminal liability even if you're the victim of a burglary. Let me break down what these laws actually say, because the details are where gun owners are getting trapped. Starting with California. Senate Bill 53. Under this law, if you own a firearm in California, and that firearm is not on your person or under your immediate control, it must be stored in a locked container or disabled with a trigger lock. That sounds simple enough, right? Just lock it up when you're not using it. But here's what most people are missing. The law defines immediate control very narrowly. If you're in your bedroom and your gun is on the nightstand next to you, that might be immediate control. But if you walk to the bathroom, is it still under your control? If you're downstairs making coffee and your gun is upstairs in the bedroom, is it under your control? The law doesn't give clear answers, and that ambiguity is dangerous because prosecutors can interpret it however they want. Now, here's the California part that's catching people completely off guard. The law applies even if you live alone, even if you don't have kids, even if nobody else has access to your home. If your gun is sitting in a drawer, unsecured, and a cop somehow sees it, maybe during a welfare check, maybe during a domestic call, maybe because you had to call 911 for a medical emergency, you can be charged. The law doesn't care that nobody was in danger. It cares that the gun wasn't locked. And here's the penalty structure in California. First offense is a misdemeanor with a fine up to $1,000 and up to 6 months in county jail. Second offense, the penalty is double. Third offense, you're looking at losing your gun rights entirely under California's firearm prohibition laws. That means one mistake, one moment of forgetting to lock the safe, and you're on a path to losing your Second Amendment rights forever. Now let's talk about Illinois, because the Illinois law is even more aggressive in some ways. The Illinois Safe Gun Storage Act says that if you store or leave a firearm in a location where a minor or a prohibited person can access it, and you know or should have known they could access it, you are committing a crime. Here's what that means in plain English. If you have a child in your home, even a teenager, your guns must be locked. Period. No exceptions. If you have a roommate who's a prohibited person, maybe they have a felony conviction, your guns must be locked. If your adult child lives with you and they're prohibited from owning guns, your guns must be locked. And here's the trap. The law says you should have known. That means even if you didn't actually know that a minor could get to your gun, if a prosecutor can argue that a reasonable person would have known, you're guilty. And the penalties in Illinois are brutal. If a minor gains access to your unsecured firearm and nobody gets hurt, you're looking at a Class A misdemeanor. That's up to 1 year in jail and a fine up to $2,500. But if that minor uses the gun, even if they don't hurt anyone, you're now facing a Class 4 felony. That's 1 to 3 years in prison and a fine up to $25,000. And if someone gets injured or killed because a minor accessed your unsecured gun, you're looking at a Class 3 felony with 2 to 5 years in prison and fines up to $10,000. But here's the part that should terrify every Illinois gun owner. You can be charged even if the minor never actually touches the gun. If they could have accessed it, that's enough. If a cop responds to your house for any reason and sees an unsecured gun in a location where a minor could theoretically get to it, you're getting charged. Let me give you a real-world example of how this is playing out right now. Imagine a guy named Tom. Tom lives in Illinois. He's 45 years old. He has a 16-year-old son. Tom is a responsible gun owner. He's had guns his whole life. He keeps a pistol in his nightstand for home defense. The nightstand has a lock, but Tom doesn't always use it because he wants quick access in case of an intruder. One night, Tom's son has a mental health crisis. The son makes a comment about harming himself. Tom's wife calls 911. Paramedics show up, police show up, they do a welfare check. An officer walks through the house to make sure it's safe. The officer sees the pistol in Tom's nightstand. The officer asks if there's a minor in the home. Tom says, "Yes, my son." The officer asks if the gun was locked. Tom says, "No, I keep it for self-defense." That officer now has probable cause to charge Tom under the Illinois Safe Gun Storage Act. Tom did nothing wrong in his mind. He was trying to protect his family, but under the law, he just committed a crime. Tom is now facing a Class A misdemeanor, up to 1 year in jail, and a $2,500 fine. And if his son had actually accessed that gun, Tom would be facing felony charges. Now, here's what most people are getting wrong about these laws, and I need you to listen closely because this is critical. A lot of gun owners think these laws only apply if you have young children. Wrong. In California, the law applies to everyone. In Illinois, the law applies if there's any minor in the home, and that includes teenagers. A 17-year-old counts as a minor. If your 17-year-old can access your unsecured gun, you're breaking the law. And here's another thing people are getting wrong. They think as long as the gun is in their house, they're fine. Wrong. In California, the law applies wherever you store a gun, including your car. If you leave a gun in your car unsecured and you're not in the car, that's a violation. In Illinois, if you store a gun at a friend's house or a relative's house and a minor lives there, you better make sure it's locked or you're criminally liable. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the exact type of gun safe that meets legal requirements in all 50 states. Most cheap safes don't qualify, and using the wrong one can still get you charged. Subscribe right now so you don't miss it. That video drops next week. Now, let's talk about what these laws actually require in terms of storage, because this is where the confusion is massive. Both California and Illinois use the term approved locking device or locked container. But what does that actually mean? In California, an approved firearm safety device has to meet specific standards set by the California Department. That means it has to be listed on the DOJ's official roster of approved devices. If your trigger lock or gun safe isn't on that list, it doesn't count. You can have the most expensive biometric safe in the world, but if it's not California DOJ approved, legally it's useless. And here's the kicker. The DOJ's roster is constantly changing. Devices get added, devices get removed. If you bought an approved safe 5 years ago and it's no longer on the roster, you're now in violation. In Illinois, the law is slightly different. Illinois requires a locking device or a securely locked box or container. The law doesn't specify a government-approved list like California does, but it does say the device must be designed to prevent unauthorized access. What does that mean? Nobody knows for sure because the law doesn't define it. So you're left guessing. Is a cheap cable lock enough? Is a small lockbox sufficient? What if the lock is easy to pick? The law doesn't say. And that vagueness is dangerous because it gives prosecutors room to argue that whatever you were using was not good enough. I've already seen cases where someone had a gun in a locked drawer, but the prosecutor argued that a drawer lock does not count as a securely locked container because a kid could break the drawer, and the person got convicted. Here's another trap that's catching people. Both laws have exceptions for immediate access during an emergency. In California, you're allowed to have a gun accessible if you reasonably believe there's an imminent threat. In Illinois, the law says you're not liable if the minor obtained the gun as a result of an unlawful entry. But here's the problem. Those exceptions are incredibly narrow, and they only apply after the fact. You have to prove in court that you had a reasonable belief of imminent danger or that the access was due to unlawful entry. Good luck with that. If a prosecutor wants to charge you, they're going to argue that your belief was unreasonable or that you should have locked the gun even during a break-in. These exceptions sound good on paper, but in practice, they're almost useless. Now, quick legal note. This is educational information, not legal advice. Every situation is different. Every case has unique facts. If you're facing charges under these storage laws, or if you have questions about compliance, you need to consult with a criminal defense attorney in your state who specializes in firearms law. Do not rely on a YouTube video to defend yourself in court. Get professional legal counsel. Let me walk you through what compliance actually looks like in 2026 under these laws. If you live in California, here's what you need to do. First, go to the California Department website and look up the roster of approved firearm safety devices. Find a device on that list that works for your situation. If you want a biometric safe, make sure it's on the roster. If you want trigger locks, make sure they're approved. Buy that device. Second, anytime your gun is not on your person, it goes in the safe or gets the trigger lock, no exceptions. If you're in the shower, lock it. If you're sleeping, it's a gray area. Technically, if it's on your nightstand and you're in the bed, that might be immediate control. But if a prosecutor disagrees, you're getting charged. Third, if you ever have to use your gun in self-defense and the police come, before they arrive, secure the gun if possible. Because if a cop sees an unsecured gun and asks why it wasn't locked, your explanation better be airtight. If you live in Illinois, here's what you need to do. First, determine if there's any minor in your home or any prohibited person. If yes, every single gun must be in a locked container or disabled with a locking device. No exceptions. Second, that locked container needs to be something solid. A lockable drawer probably isn't enough. A cheap cable lock might not be enough. Get a real gun safe, spend the money. It's cheaper than a felony conviction. Third, understand that prohibited person doesn't just mean a felon. It includes anyone who's been involuntarily committed to a mental health facility, anyone with certain restraining orders, anyone with specific misdemeanor convictions. If you have a roommate or a family member living with you, make sure they're not a prohibited person. If they are, your guns must be locked at all times. Fourth, if you don't have minors or prohibited persons in your home, you're in a better position, but don't get comfortable. Illinois law can still apply if a minor visits your home. If your neighbor's kid comes over and accesses your unsecured gun, you're liable. Now let me talk about the situation that's scaring a lot of people. What if you're the victim of a crime? What if someone breaks into your house and steals your gun because it wasn't locked? In California and Illinois, you can be charged for failing to secure the gun even though you are the victim of a burglary. Let me say that again. Someone breaks into your home. They steal your unsecured gun. You report the theft. The police investigate, and then they charge you with improper storage. It's insane, but it's happening. I've already seen cases where homeowners in California had guns stolen from their nightstands. The guns were later used in crimes. The police tracked the guns back to the original owner and charged that owner with a storage violation. The argument is that if you had locked the gun, the thief couldn't have taken it. Never mind that the thief broke into your house. Never mind that you're the victim. Under these laws, you're now the criminal. And here's the worst part. If your stolen gun is used in a crime, you could face additional liability. California has talked about laws that would hold gun owners civilly liable if their stolen, unsecured gun is used to hurt someone. That's not fully in effect yet, but it's being pushed. And even without that, you're looking at the criminal charge for improper storage, plus the emotional trauma of knowing your gun was used to harm someone, all because you didn't lock it. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these critical legal updates first. Click that subscribe button right now because next week I'm covering the exact wording to use when police ask to search your home for guns. One wrong sentence can waive your Fourth Amendment rights. Don't miss it. Now let's talk about enforcement because this is where these laws get really scary. How are police finding out about unsecured guns? Here's the reality. Most of these charges are piggybacking on other police encounters. A domestic violence call, a welfare check, a noise complaint, a mental health crisis, anything that brings police to your door. Once they're inside, if they see an unsecured gun, they're asking questions. Do you have kids? Is anyone in the home prohibited? Where do you normally store this? And your answers are creating probable cause for a criminal charge. I've seen cases where someone called 911 because they were having a medical emergency. Paramedics arrived. Police arrived to secure the scene. An officer saw a gun on a table. The officer asked if there were children in the home. The homeowner said yes. The officer asked if the gun was normally stored that way. The homeowner said sometimes. That homeowner is now facing charges. And here's another way these laws are being enforced. Revenge reporting. Angry ex-spouses, bitter neighbors, disgruntled family members. If someone has a grudge against you and they know you own guns, all they have to do is call the police and say, I'm worried about the safety of the children in that home. I think there are unsecured guns. The police will show up. They'll ask to do a welfare check. And if you let them in and they see an unsecured gun, you're getting charged. And even if the report was completely made up, even if it was just someone trying to get you in trouble, the charge is still valid if the facts support it. This is how these laws are being weaponized against gun owners. Some jurisdictions in California and Illinois are even doing proactive enforcement. They're sending letters to registered gun owners, reminding them of the storage laws and saying, we may conduct random compliance checks. That's insane. The idea that police can just show up at your door to check if your guns are locked is a massive Fourth Amendment issue, but it's being pushed. Now, let me address the question everyone's asking. What about the Second Amendment? How can these laws be constitutional? Don't you have a right to keep a gun for self-defense, and doesn't that mean it has to be accessible? Well, here's the legal reality. The Supreme Court has said that the Second Amendment protects your right to keep a firearm in your home for self-defense. That was District of Columbia versus Heller back in 2008. But the court also said that right is not unlimited. The court specifically mentioned that laws requiring safe storage of firearms to prevent access by children are presumptively lawful. So the Supreme Court has already given a green light to storage laws, at least in principle. Now, the question is whether California and Illinois have gone too far. Are these laws so restrictive that they effectively prevent you from using a gun for self-defense? That's the argument gun rights groups are making. And there are lawsuits challenging these laws right now. But as of February 2026, these laws are in effect. They're being enforced. And until a court strikes them down, you have to follow them. Let me give you another hypothetical to show how absurd this can get. Let's say you're a single woman living alone in California. You've had a stalker, you filed police reports, you're terrified, you buy a gun for self-defense, you keep it in your nightstand so you can access it quickly if he breaks in. One night, you hear a noise, you grab your gun, you call 911, the police come. They don't find the stalker, but they see your gun on the bed. They ask where you normally store it. You say in the nightstand, unlocked, because I need it for protection. The officer tells you that's a violation of the storage law. You explain about the stalker. The officer says, I understand, but the law requires it to be locked unless it's on your person. You're now facing a misdemeanor charge for trying to protect yourself. That's the reality of these laws. They don't care about your circumstances. They don't care that you're in danger. They care about the letter of the law. Now, here's a question I keep getting. What if I have a quick access biometric safe? Does that count as locked? The answer is yes, as long as the safe is on the approved list in California or meets the secure container requirement in Illinois. A biometric safe that opens with your fingerprint in 2 seconds is probably your best option if you want both compliance and quick access. But here's the catch. Those safes are expensive. A good biometric pistol safe costs anywhere from $150 to $500. If you have multiple guns, you need multiple safes or one large safe, and now you're looking at thousands of dollars. And if you can't afford that, too bad. The law doesn't care. You either comply or you're a criminal. And this is one of the criticisms of these laws. They disproportionately hurt low-income gun owners who can't afford expensive safes. But that's a political argument. Legally, you still have to comply. Let me also mention the car storage issue because this is catching a lot of California gun owners. California's law applies to guns stored in vehicles. If you leave a gun in your car unattended, it must be in a locked container. That doesn't mean your car's locked doors. It means a separate locked container inside the car. A lockbox in the trunk, a cable lock through the action, something. If you just leave a gun in your glove box and your car is parked, that's a violation. And if your car gets broken into and the gun is stolen, you're getting charged with improper storage on top of dealing with the theft. Some people are saying, well, I'll just never leave my gun in the car. I'll always carry it on me. Great. But what if you have to go into a place where guns aren't allowed? A courthouse, a school, a federal building. Now you have to go back to your car, lock the gun in a container, and then go inside. And if you forget, if you just leave it in the glove box, you're breaking the law. This information could literally save you $10,000 and years of legal hell. Subscribe now because my next video explains exactly what happens when you have to use your gun in self-defense and the police want to inspect your home storage. I'll give you the script that protects your rights. Hit that subscribe button. Now, let's talk about what happens if you're charged under these laws. First, understand that even a misdemeanor gun charge can destroy your life. A misdemeanor conviction for improper storage can result in a 10-year federal ban on possessing firearms under federal law if the conviction is for a crime involving domestic violence. Even if the charge has nothing to do with domestic violence, prosecutors in some jurisdictions are stretching the definition. If the improper storage involved a minor in your household, they argue it's domestic in nature. And boom, you're federally prohibited. Second, a conviction, even a misdemeanor, shows up on background checks. If you ever apply for a gun permit in another state, if you try to buy a gun, if you try to get a concealed carry license, this conviction will come up. And in many states, it will disqualify you. Third, in California, multiple convictions for storage violations can lead to a lifetime ban on gun ownership under California law. 3 strikes and you're out. Literally, you lose your Second Amendment rights permanently. And fourth, these charges often come with other consequences. If you're charged with improper storage and there's a child involved, Child Protective Services might get called. They might investigate whether your home is safe for children. They might remove your kids while the investigation is ongoing. Even if you're found not guilty, the damage to your family is done. So the stakes here are not just fines and jail time. The stakes are your gun rights, your freedom, your family, and your reputation. Now, let me give you the action steps you need to take today if you live in California or Illinois. Step 1, audit your current storage situation. Walk through your house right now. Where are your guns? Are they locked? If not, you're in violation. Fix it today. Step 2, buy approved locking devices or safes. In California, check the DOJ roster. In Illinois, get something solid. A cheap cable lock is not worth the risk. Spend the money on a real safe. Step 3, establish a storage routine. Every time you're done handling a gun, it goes back in the safe. No exceptions. Make it a habit. Step 4, if you have children or prohibited persons in your home, triple check your compliance. These laws have zero tolerance for mistakes when minors are involved. Step 5, be extremely careful about what you say to police. If police ever come to your home for any reason and they see a gun, do not volunteer information about how you normally store it. Do not let them search your home without a warrant. Politely decline to answer questions without an attorney present. Your words can and will be used to charge you. Step 6. If you're ever charged under these laws, hire a lawyer immediately. Do not try to handle this yourself. Do not talk to the police without a lawyer. Get a criminal defense attorney who specializes in firearms law in your state. And step 7, stay informed. These laws are new. There's going to be litigation. There's going to be clarification. Subscribe to channels like this, follow legal updates, and adjust your compliance as needed. Now, let me address one more thing that's going to come up. Some people are going to say, I'm not going to comply with these unconstitutional laws. I have a right to keep a gun for self-defense, and that means it has to be accessible. I'm not locking it. Here's my response. I understand the frustration. I understand the constitutional argument, but let me be blunt. If you choose not to comply and you get caught, you're going to prison. You're losing your gun rights. You're paying massive fines. You're destroying your life. And for what? To make a point? To be a martyr? That's not strategy. That's stupidity. If you want to fight these laws, support the legal challenges. Donate to gun rights organizations. Vote for politicians who oppose these laws. But don't gamble with your freedom by refusing to lock your guns. It's not worth it. Follow the laws that exist today and work to change it through the proper channels. Here's my final point. These storage laws are a glimpse into the future of gun control. Anti-gun politicians have figured out that they can't ban guns outright because of the Second Amendment. So instead, they're making gun ownership so burdensome, so expensive, so legally risky that people just give up. They're turning law-abiding gun owners into criminals for technical violations. They're imposing thousands of dollars in costs for safes and devices. They're creating a legal minefield where one mistake destroys your life. And it's working. I've already talked to gun owners in California and Illinois who are selling their guns because they can't afford the safes or they're terrified of making a mistake. That's the goal. Death by 1,000 cuts. So here's what I want you to do. Don't let them win. Comply with the law. Protect yourself legally. But don't give up your rights. Buy the safe. Lock your guns. Follow the rules. And keep fighting for the Second Amendment through the legal and political process. Look, I spend hours every week researching these laws, reading statutes, talking to attorneys, and breaking down the legal traps so you don't have to. The least you can do is hit that subscribe button to support this channel and make sure you never miss an update that could keep you out of prison and protect your rights. Subscribe right now. And if you found this video helpful, share it with every gun owner you know in California and Illinois, because most of them have no idea they're one welfare check away from a criminal charge. Remember, this is educational information based on California and Illinois state law. It is not legal advice for your specific situation. Always consult with a qualified criminal defense attorney in your state before making decisions about firearm storage. Stay safe out there. Know your rights. Lock your guns. And don't become the next victim of these predatory storage laws.